All right, good morning, everyone, and welcome to our second Impact International Safety Call. We're thrilled to have you here with us this morning. I'm really excited. We've got a great guest speaker who's going to be bringing some real pertinent stuff to us. Got a few other items I want to take care of before we get rolling with him. Just want to hit on a couple things that Impact has going on. July 15th through the 19th in Ann Arbor, Michigan, there is the contractor courses being offered along with the iron workers who are going to be there, hundreds of them getting training that they give to the apprenticeship instructors. So it's a whole week in Ann Arbor. If you're a new contractor or someone who's contemplating becoming a contractor, there's some great classes being offered throughout that week. We'd love to see you there. Any of that information about Ann Arbor is on the Impact website, but I would highly recommend it. I know there's also a safety roundtable going to go on while we're there. A lot of great information is shared at that. So if you can make it out there, I would urge anybody that can to be there and participate. The other thing I wanted to hit was coming up, the 2020 Impact Conference is actually going to be in Chicago this year, coming year, April 14th through 17th. So I know that's still about 10 months out for us, 9-10 months, but it's a great time, a lot of great information. You meet a lot of people, and it's really pertinent to what's going on today in our industry. We're also, again, this year going to have our contractor only day at the end of the conference. So it's a good time for contractors just to get together and talk about what's going on. So I would urge everybody to put that on their calendar. I know it's a long ways out again, but it's a great time. And this year we're going to be in Chicago, which is going to be different for us and just kind of add to the overall group. I want to also highlight Vicki O'Leary, who, for those who don't know, was selected as E&R's Person of the Year. She works for the International. She's the Director of Safety and Diversity. She's done an awesome job. And those of you who aren't familiar with E&R's Person of the Year, it's basically like she's won the Academy Award for our industry. So kudos to her, great job. It's a really big deal. So Vicki's been working hard and keeping the iron workers at the forefront of diversity and inclusion. A lot of great things she's doing in the industry, and it was neat to see her get recognized. It's a big deal for her, a big deal for the iron workers and our trade and our industry in general. I also want to thank General President Eric Dean, for being our guest speaker last time. He really, I think, helped set the table for what we're trying to do at Impact and the idea behind this call as we move forward. He had a lot of great information, and really appreciate that. So with that, I want to introduce today's guest speaker. His name is Jim Stanley, and I'm turning on his video now as we speak. Jim began his career investigating accident at the Philadelphia waterfront for Liberty Mutual Insurance. In early 1971, he joined the U.S. Department of Labor, Occupational Safety and Health, or OSHA, and was one of its original compliance officers. He spent 25 years with OSHA in roles from working in an area office, regional director, national leadership roles, including regional administrator for New York, one of the most industrialized regions in our country. During his tenure, he was intimately involved in many of the most complex cases and was instrumental in creating many of the current OSHA policies and procedures. He also held that role, or it culminated his appointment as Deputy Assistant Secretary of Labor. So that's a big role. I know Jim's had a lot of his hands in what OSHA does, the rules that were written. After retiring from OSHA in '96, Jim went to work for AK Steel as their Vice President of Safety and Health. He was there for 8 years and really helped them develop a world-class safety program. He's a former member of the Board of Directors of Executive Committee of National Safety Council. He's on the Safety and Health Committee for the Association of Iron and Steel Technology. He's also served 2 terms as a national advisory for the Occupational Safety and Health 12-person committee that is a preeminent advisor of the Secretaries of Labor and Health and Human Services and Occupational Safety and Health. So Jim, we're thrilled to have you with us today. I would urge everyone to, as Jim goes through his different topics, if you have questions, please ask. That's what we're here for. Jim's a absolute wealth of knowledge on the industry, and look forward to answering your questions. So Jim, with that, the time is yours.
Morning, everybody. Great to be an American. It's a pleasure to, I really appreciate the ironworkers and the impact contractors for inviting me and trying to help you understand what's happening out there with OSHA and the steel erection industry. Right now, OSHA is more aggressive in their enforcement actions than I can remember, including the recent administrations. What's happening is that there's no leadership in the, or a lack of leadership in the national office. Men and women that understand your industry, men and women that understand construction and general industry. They're just not there, and they just, they have a lot of hardworking career people there, but they're not, it's not working. The area offices and the regional administrators, they're doing their own thing along with the state plans. And we're seeing more and more major citations. We're seeing more citations and violations being issued in areas where there's a lot of questions. There doesn't seem to be a tremendous amount of review of these issues. And what's really happening is the regional administrators are taking over, and the solicitor of labor is advising them, and basically a major role in the administration of the agency. And to that end, Steve Rank, the ironworkers, the safety director for the ironworkers, and I have been asked by Impact and the ironworker union to assist contractors where the citations and the violations in the citations really don't make sense and don't improve safety. And we've had quite a few of contractors that have come to Steve, and Steve and I worked with them on a regular basis to resolve these matters with the agency. And it's becoming more difficult to resolve, to be honest with you. Some of the cases involved a requirement of OSHA for steel-toed shoes for every ironworker. And it came from an ironworker that was unloading the truck and worked some of the pieces of steel pieces were oblong and misshaped, and they were on the ground, and there was he walked over to unhook them, and one of the pieces moved slightly and injured his foot. All well and good on a specific situation, but then the citation came out requiring this contractor to put in steel-toed shoes for iron workers throughout all of their operations. And one of the principles that we all go by is we shouldn't do something to be in compliance if it creates a greater hazard. And that was the situation in that, and we finally resolved it to the benefit of the ironworkers and the ironworker contractors. We had another case where ironworker was welding decking in a controlled decking zone. Installing decking in a controlled decking zone. OSHA came in and required them to permanently weld as the decking was being placed. And they didn't agree that spot welding was good enough to secure the decking in place, and they wanted it permanently welded. Of course, that creates a huge issue because you come to the end of your decking, and if it's not aligned properly or there's something off, you got to go back and rip it all up again and start over. So that was an issue, and that took a while to resolve. we had another contractor landing bundles of decking into a about 24-foot, 28-foot area. This was an area where the contractor and the general contractor were permitting the OSHA standard to apply, 1530, and the exception for connectors between 15 and 30 feet, where they could have some flexibility as long as they had their harness on and they could immediately connect if there was a boom deflection or if the decking was moving, which all of them would say was absolutely necessary in that type of situation. But the OSHA took the position that this work was not connector work, that anybody can do it and it's not connecting, therefore the exemption didn't apply. That went to a hearing and the judge agreed with OSHA, and now I believe it's even being appealed to circuit court. Very interesting. Of course, if it's a 6-foot job, everybody is going to be tied off no matter what. But my feeling is that if you are tied off in that situation, you got to do it in such a manner with horizontal lifelines, probably, and ability to move away in case of a problem. So that issue is ongoing. And we had another issue in a rebar installation job where OSHA actually changed the wording of the standard to, instead of just impalement hazard where you have to guard it, bumping into hazard, they added to the actual words of the standard. And they didn't want to change it. And there was no impalement hazard, but they still required the rebar contractor to guard all of the rebar in a area where they were eventually just going to pour the concrete on the ground. So that one was eventually resolved. And then we're seeing also moving of steel beams with shakeout hooks in a fabricator location. And also the qualifications of the spotter rigger, where this employee had been actually gone through the apprenticeship training program, was in fact a qualified rigger, but OSHA had severe questions on that, and that's an issue that's ongoing. So we're out there every day trying to help contractors, trying to help the iron workers, and to get a fair shake. But the consistency of OSHA remains a big difference. There is a big difference between many regions, between area offices, and even in state plan states, within the states and between the state plans. And I want all of you to remember that state plans can have different rules for steel erection, but those rules cannot be less stringent than what exists in Subpart R. They can be more stringent, as in some of the rules in California, but they cannot be less stringent. So you have to really be on your game as to what the local, what the area offices are requiring and what the state plans are requiring if you're in one of those areas. Before we get started and going through some of these issues, I'd like to talk a little bit about maybe just 2 things that I think each one of you needs to do to prepare for an OSHA inspection, deal with an OSHA inspection, and come out of an OSHA inspection with a really great result, meaning that you're working safely and there are no hazards to your employees. If you're a contractor or if you're an iron worker, there's no hazards to you. So one of the things that I recommend to everybody is every single safety person and superintendent and management and union steward or any iron workers that are on the job, you have to understand what the multi-employer worksite citation policy is. You can Google it. OSHA's worksite citation policy. OSHA's worksite, multi-employer worksite citation policy. Google that and read it. It goes through every ironworker contractor is an exposing employer. We understand that. But there's 3 other categories that OSHA talks about and uses in their enforcement action. And that is a controlling employer, usually the GC or prime contractor, sometimes the owner. And then they have a creating employer, which is the employer that actually creates the hazard and may not even be there when somebody gets injured because of the issue that they created. And a correcting employer, usually a separate employer that comes to a job to corrects issues as required by the general contractor. So you have 4 different categories. You need to read this. It's not a rule, it's not a standard, but 2 entities are really using this. And the one entity is OSHA. OSHA now can, and for years and years, up to 1994, OSHA could not cite unless the employer had exposed employees to the hazard. That changed in 1994. And again, this policy is being enforced or used intermittently, differently in many areas, differently in the state plan states, sometimes not at all, but it's out there. And then, of course, if there's other litigation that goes on, contract litigation, employee injury litigation, third-party litigation, all of that stuff, those lawyers are all using this document to hopefully prove they want to prove their case through this document. So it's very important that you understand what it is. Second thing that I recommend to everybody, and this is repetitive at a minimum, but as you know, OSHA requires in their general construction regulations that each employer, like a steel erection contractor, has to have a safety program, and that safety program has to include a provision for regular and frequent inspections by a competent person. We all know what a competent person is, but they have to be doing that. And I would just stop and say right here, if your safety department doesn't have what OSHA defines as a competent person doing this work, it's time to really take a second look at this. Your safety department should be made up of all competent persons as defined by OSHA. And if you don't have that, then you need you can go out and get that training. You can the ironworkers, as a matter of fact, offer a safety director training course for ironworkers that goes through 40 intensive hours of safety training in all aspects. I'm one of the instructors in that course. They've done it 7 times through the United States and Canada. That will qualify, that could qualify your employees as a competent person. But moving on with that, my recommendation is, and if every single erection contractor out there, or any contractor out there, every single day you need to be inspecting your workforce. Throw away the checklist. Go out with competent people and inspect for hazards every day. Document those hazards and get them corrected. And then turn that documentation into your management and also to the controlling contractors management. Whether they want it or not, you need to make them establish that relationship with them, that you're going and you're doing everything that's required of you to provide a safe workplace for your employees. I I can't tell you how far that goes with OSHA. It goes a long way, and it will improve their attitude towards you. Right now, steel erection contractors are on the top of the list. Why? It's evident. They see you. They see you when they're driving to another job. Other people see you in operation. You are going to be inspected, and you have to be prepared for that. So, again, we're probably going to run out of time, but if you have questions, you can email those questions in, and we'll start answering them as we go through this. So, hi,
Jim, thanks. That's great opening stuff. Lot to think about and work on. I would too recommend the Ironworker Director Training course. I've sent multiple people through it. It's worth every penny and every minute. I know you've done 7 of those. I talked with Steve Rank this morning, and I know there's one coming up in Canada. So anybody who's on the line within Canada, that should get you excited. We actually have a question right now from an anonymous attendee. I'll go ahead and read it. Let's see if we can't get it answered. He says, and I read this, and it's a good one. OSHA doesn't currently have a leading edge requirement, but under the general duty clause, it would be a requirement. There is still a lot of testing being done with these leading edge devices. Is OSHA enforcing leading edge and citing contractors that don't have leading edge?
My understanding is, first of all, we all have to understand what leading edge is. Leading edge is, well, let's read the definition of it. So I have it right here, and so we're all on the same page on leading edge. Leading edge means the unprotected side and edge of a floor, a roof, or formwork for a floor or other working surface, such as a deck, which changes location as additional floor, roof, decking, or formwork sections are placed, formed, or constructed. Leading edges in OSHA for ironworkers, that leading edge has to be guarded, and it's a performance standard. We have specification standards and we have performance standards. But this is a specification standards. This is a performance standard, excuse me. Guardrails, safety nets, fall protection systems. There is no safe distance. OSHA does not recognize a safe distance. So if you're 40 feet away from the leading edge, OSHA says you must protect. I know sometimes that makes no sense. And there is a clause in the law. There is a lot of decisions that says the exposure has to be reasonably predictable. But for the most part, compliance officers require guarding. The method of that guarding is entirely up to the contractor. OSHA cannot tell you how to guard. I hope that answers their question.
I would throw onto that then, kind of, because this is something that's pertinent to the way we do things. We use retractables a lot when we're laying deck and working that open edge. There's come out now, some of these retractables are quote unquote becoming leading edge retractables, meaning the cable is heavier. So have you seen anything where OSHA's started to glom onto that, or are they not there yet? I think might be the final answer to this question.
Well, the technical advances, when this standard was originally written in the middle of the 90s and by a rulemaking consensus group of contractors and unions and public and OSHA, and it was the first time OSHA ever did anything like that. The technology really wasn't there for ironworkers for protecting people at 6 foot, 8 foot, 9 foot, 10 foot. You're going to hit the ground if you were in a fall arrest system. Today, we're going to a lot of fall restraint systems and a lot of short self-retracting lifelines on the D-ring and shortened lanyards and protection, and you can do it. There are ways to do it. But if you don't do those things, for the most part, on a regular fall arrest system, you're banging off the ground before you ever, and you're providing a false sense of security. That's one of the reasons it's 15 foot in the OSHA standard. I understand that most of the large contractors, the Turners, the AECOMs, the Clarks, everybody that's out there, Bechtels included, they're all requiring 6 foot. That's hard to do. It is really hard to do with a fall arrest system. There's got to be other ways. And I am seeing those other ways coming around, but they're mostly restraint systems, not fall arrest systems.
Okay. We got a comment here from Tony Hannon. He says the ANSI standard is clear when it comes to leading edge. So how does OSHA and the ANSI standard mesh up? What are your thoughts there?
Unfortunately, ANSI standard, it's done by it's put together. ANSI generally is a very competent, very well-respected consensus standard making body. And their standards are voluntary. They are not mandatory unless OSHA adopts their standards, which OSHA should be doing. I love the agency. I worked there forever. They missed the boat on keeping their standards current by not going and working with ANSI and other consensus standards to modernize the standards. Again, this is a 1994 standard put into effect in 2002. And the leading edge, they talk about the leading edge, and they are. And Tony, a good friend of mine, is very right on this. And if you want to do better than what OSHA says, you can do that. And again, OSHA doesn't care if you do more. OSHA's the minimum you must do. So that's the answer. They work together, but they can't cite the ANSI standard.
All right. Looks like we got another question coming in here from Andre Mondu. Sorry, Andre, I'm sure I slaughtered your last name, but he writes, is it legal to install temporary perimeter cable for top run to be 48 to 49 inches before concrete is poured? Because after slab is poured, it will be 22 and 44. And that's a great question because we just ran into that on a job. What are your thoughts there, this pre and then post concrete, where the slab can run from 3 to 8 inches thick?
So we all know the rule. After the deck is down and completed, the iron worker is required to install perimeter cable. Okay? That perimeter cabling is the same as the standard for guard rails. 42 plus or minus, 21 plus or minus, and a toe board if there's no toe board required in that particular case. The issue has always been this issue. What do? If I install that 48, I'm now not in compliance with the standard. If somebody goes through there after you have left the job, one of those guys, guess who's on the hook? Erector. My recommendation is you install it in accordance with the standard and do the protection for that. If the concrete guy wants to change it, he has to change it. And you turn it over to the controlling employer. That's the way it works. Do that. Don't put yourself in the position of creating a hazard for somebody else. Why would you do that? That is not good. So that's my answer to that.
Okay, understood. So basically, install it per the standard, and after it's installed, and I think everybody understands that, you have that form, or you should have that form that turns control of it over to the controlling contractor. Once that concrete is poured, it's their baby. They can adjust it from there. Got it.
I agree.
Okay, good question. Next question coming in here from Anonymous says that the general contractor is not willing to execute the steel erected standard anchor bolt notification. Looks like they spec out some sections in the Cal OSHA. Is it acceptable for the general to send the notification via email with their title block and name signature. So looks like they're
I don't say this very often, but I don't know. But
okay.
I know there has to be a written notification. And there's
Yeah,
quite a
so
few things, and that's one of the subjects we're going to talk about right now is what is the controlling contractor got to do? I want everybody to remember something. They got things that they got to do. There's 4 or 5 of them listed in the standard, and they have to do that. So number one, I'm recommending to every contractor, before this job ever starts, you sit down and establish a relationship with that controlling employer. They want to hear from you. They want you to do the right thing. They know they have things they got to do. You have things that you have to do. Set up what you're going to do. That's the time to decide, and hopefully we'll talk about this in a minute on steel erection plans, but we would be discussing the steel erection plan. We would be talking about the concrete notifications. We would be talking about the access roads and the firming of all the ground. We would talk about all these issues now before we ever start, so we have the relationship on who's doing what. Understand this. If they don't give you that notification and you go ahead and work and something happens, guess who's getting cited? And you're going to be responsible. Don't put yourself in that position. If they don't give you the notification on the concrete, if they don't tell you about any repairs to the anchor bolt systems and so forth and so on, if they don't talk about, if they put in, don't firm up the ground, drain it, make the access roads in there, pre-plan with you the operation of all the cranes, if you let them not do that, you're buying it. You're buying it. And so you have to have that relationship where you can stop and say, hey, what about this? And they're going to have the relationship. Believe me, they don't have any problem stopping you. So you need to be able to say, hey, this is the issue here.
I know we fight that battle. Sometimes it seems on a daily basis, and many times it comes up on the smaller jobs where you may just be in doing a small addition on a school, and you go to that controlling contract and say, hey, you need to sign off on this. And brand new soup, never done it before. I ain't signing that. And I think that's probably what this person has run into. But those are things that we face on a daily basis, all those issues you just hit. And I agree, having those discussions ahead of time is huge. It does seem to be getting a little better, but boy, you still run into that smaller company or that new soup that just isn't aware, and it can still become a battle. But good question, and I hope we answered that. Next one's from Kevin Hildebrandt. He writes, not a question, rather a comment. He said, we were cited in Michigan for not using a leading edge retractable in a leading edge decking situation. All ironworkers are tied off, but not with a leading edge retractable. My OSHA referred to the manufacturer's instructions and limitations and cited off of the manufacturer's instructions. This was about 2 years ago. This is my personal experience. So any comments there where it seems that in Michigan, my OSHA is basically referring to manufacturer's specs and recommendations?
First of all, it's not a specification standard. As they say, they talk about fall protection at the leading edge. They don't tell you how to do it. They never are supposed to tell you how to abate. They want to take that responsibility. When I was in OSHA, I'm going to tell you how to abate. You abate that way and somebody gets hurt. You think OSHA's going to buy that? They're not. You cannot lose that case if you have a competent representation. They cannot tell you how to abate. They can tell you that your abatement isn't adequate. They might say that, and that would be a failure to abate situation. But if you're protecting your employees by whatever means, you could, on a leading edge, we can install nets. We can put railings up. We can remove exposure. You take away exposure, no violation. There's a lot of ways to correct. So I feel for Mr. Hillenbrand. I feel for him, and I know the frustration because sometimes the agencies or the state plans wants more authority and tries to get more authority than they really have. They cannot tell you. They're not the experts on how. You are.
Understood. And I would back that up. I know, Kevin, we had a situation that was somewhat similar, and got Steve Rank and Jim involved, and actually were able to come out on top of that one for a very similar thing. So I guess that's one where, if you can, contractors out there, reach out to Impact, reach out to Steve Rank or Jim, and see what you can do to fight that one at least. So next one from Anonymous. Who is responsible in the event of an incident for when a policy above a standard is enforced by a GC, i.e. the use of PFAs or aerial lifts for unloading trucks? So it looks like if there was an incident that was above and beyond what OSHA says, but a GC required it, who's responsible for that?
This is really a good question, and I'll relate it to 6-foot rule of a general contractor versus the 15-foot rule in OSHA. Now, everybody understands that if the general contractor sets the rules and they want 6 foot, if we want to work there, we're going to do 6 foot. That's the way that works in life. I'm okay with that. But I have had situations where they come out to the job, we're working against we're not doing what the general said. We're working at 10 or 12 or 13 foot. And they cite based on the general contractor's rules, not the OSHA rule. That doesn't work. That's not going to work. Where it works is in the resulting third-party litigation, where you were advised and required to do something, you ignored it and went on with your work, and somebody got injured. That could be basis for negligence. And I'm no lawyer, so I'm just trying to say it could be a problem. The 15-foot rule in fall protection is the minimum. Many states have even said we want it to go to 6. If that's the case, that's more restrictive. They have every right to do it. But where they have not done it, and where we are just at a 15-foot rule, and you're working out there, my suggestion is you work within the general contractor specifications. That's what they're doing. That's what you got to do. Who's responsible? If somebody gets hurt, the first responsibility is going to be the employer of that employee. They have the responsibility under OSHA to provide a safe workplace for their employees. So that doesn't change, and that's non-delegable. That's not going to change. Will the general be responsible? Will another contractor be responsible? It all depends on the facts. So, and I don't want to talk about litigation here. We want to talk about what we're doing. Mm-hmm. My answer is you work it out with the controlling employer what you're going to do. And this is the perfect time to talk about steel erection plans. We made an error when we put this standard together. We didn't make steel erection plans mandatory. Read the standard. They're only required if you want to use one of the exceptions in Christmas tree or working over people working over a couple other areas. All right. Most contractors I deal with do a site-specific steel erection plan. I recommend it highly, regardless of what the standard says. And everybody, and if you go to Steve Rank's course on Subpart R, he's going to tell you a steel erection plan is absolutely the way to go. I am a big proponent of it. Everybody I know in my business is a proponent of it. It works. It doesn't work if it's generic. It's got to be site specific. And that's, again, let's go back to that original meeting with the general contractor and you presenting your steel erection plan, dealing with all the areas that you think are necessary to be dealt. So, any other questions? Because I want to move on if we can.
We got one more, and it's a good one. I think it's something that that all of us run into from time to time. Nick Schaefer asks, what if the controlling contractor refuses to take custody of the fall protection perimeter cable?
Take it out. There's a provision in the standard that says all fall protection devices cannot be left unless they want it. And they being the controlling employer. It's right at the end of the standard. It's almost the last paragraph. Okay? Take it out. Leave.
Take it out.
Absolutely. If they don't want to take it and they don't want to authorize it and they don't want to sign off on it, leave. You're not there anymore. You're done with the job. As long as your people are there, yes.
Mm-hmm.
Take it out.
And I can tell you, we actually did that once, or started the process. As the cable started to come down, the attitude changed real quick. That person probably made a call to corporate, and they said, no, we are in control of that. So all of a sudden they signed, and the little bit we had taken down went right back up. So I would agree with that. So yeah, right now we don't have any other questions in the docket here. So if you've got some other things you want to move on to, that would be a great time.
I do. I'd like to talk a little bit about qualified versus competent persons. I'm running into issues, especially in the rigging area. The apprenticeship program has been accepted as training by the U.S. Department of Labor. Matter of fact, the Ironworker Apprenticeship Program is probably recognized as the best program of its type anywhere in America. They go through extensive training on rigging, and I believe they're qualified and meet the qualifications. There have been numerous OSHA compliance officers that want to see employer training on this issue. My recommendation is, if you're using exclusively the training provided by the ironworkers, that you have the documentation there for them to see the course content and the when it was done, and that he successfully or she successfully completed it. Very, very, very important. And this moves over to a lot of different areas: competent person versus qualified person. The inspections, again, I will say, your inspections have to be done by a competent person. You can use a qualified person. Understand the difference in the standard. It's very clear. So I don't really believe that should be an issue. One of the things that is disturbing, though, is there is a specific training requirement in the OSHA standard for fall protection. It is 7 something, if you guys have it in front of you, but it's there. It specifically outlines the training that every one of your workers must have. Training on controlled decking zones, training for connectors, training in various other areas. You have to be able to document to OSHA, and hopefully to the construction manager, that this training has been completed. So if you can't document that those areas have been discussed and trained of all your workers that are exposed to falls, you're going to have a problem with OSHA. You're going to have a problem with the controlling employer. And if there is a issue, you're going to have a big, big problem with OSHA, a bigger problem with OSHA. So my recommendation is to read through the training section at the end of the standard and implement it. Everybody should be trained. I once asked a I once asked, I ask it a lot, uh, who's really the key people on the jobs here, on your jobs? Who are the key people in regard to safety? And everybody wants to say, well, our safety guys are responsible for safety. I disagree with that. It's management's responsibility to provide the safe workplace. The safety department cannot be everywhere on your jobs all the time. But foremen can be. And management, foremen are managers. Even if they're hourly, they're managers as far as OSHA is concerned. And you need to make sure that you're not delegating all the safety responsibilities to one or two individuals and letting go the people that really can make the change, and that's the foreman. Ask your foreman how many of them have read and understand subpart R. Ask them. If they give you a lazy look, a glazed eye look, you know you got a problem. There is where your issues are. If you can get the right people trained and enforcing, and people are held accountable to this, workers understand and know how to do these jobs safely. But if there is, sometimes we take shortcuts, sometimes we lose focus. We have to have management in there, understanding the hazards and enforcing the rules. That will go a long way for you to becoming world class in your operations. The next issue is an issue that is one that I like to talk about a lot more, and we're not going to have time, but double connections. First of all, to be honest with you, my experience with OSHA is they don't understand what a double connection is. They've had no real training in any of their classes on double connections. And the facts are that that is extremely hazardous operations. You all know it. And we had a recent situation, the result of which we have a very young first-year apprentice who was connecting in a double connection, have the beam that he was sitting on, the first beam, and tied off to go down, and he is seriously, seriously injured. At the same time, the raising gang foreman never said a word. The fellow employees never said a word. The safety guy was on the ground watching the operation, never said a word. And the superintendent knew about it. What happened was the columns came in without the seat. No one decided that they would install the seat for the first member. There was no staggered bolt holes, and this employee left a aerial lift and went to the beam, tied off to the beam, and removed the first nut and bolt, and used his spud wrench, and then the second one. And as the second beam came in, something happened. We don't know exactly, but that made it tap the column. I don't know. And that beam came down. Someone had to train this first-year apprentice on how to do it wrong. You just don't wake up one morning knowing how to do that, the way it was done prior to 2002. This is something that every one of you, if you're doing double connections, you have to make sure that this cannot happen. This is really a big deal. And the injuries that result are death or serious physical harm every single time. And they don't happen that often because most employers and most iron workers are very cognizant of the hazards associated with this operation. Any questions on that, Pete?
You know, I haven't seen any questions come in, but I want to comment on that. Can you hear me right now?
Sure.
Okay. The double connection, I think I want to make everybody aware. I think most contractors know and understand, you know, the no more of the true double connection, that you use that angle underneath or the offset bolt hole, something so that we avoid that. Where I think a lot of people get in trouble, and if you're management and you're watching this, or you're the safety person, and like you said, you're not on every job at every time, you have that line you're working down and the connectors are working. All of a sudden, beam 32A is not there. It's on the other load. It didn't get there. What do the guys do? They skip by it, right? And they keep erecting. Well, when you come back to that piece that was missed, you're now out of order. And so you're going to have to make, at some point in time, pull bolts to slide that beam in. So I think everybody should be aware that I think that can and does happen. So you need to get a policy in place that explains to everyone, and everyone understands, all your iron workers, that if this happens, you got to weld the seat. You have to do this, whatever you want to come up with for your company. But anybody that's thinking, boy, that never happens, all it takes is that one piece is missing or it's made wrong or something, and the guys are in a hurry and everybody wants production. You know, we want our 70 pieces a day or whatever you bid that job at. We want it hung. They go by. When they come back to that beam, they're going to be not in compliance unless they take that step to weld in a seat, punch an extra set of holes, something to keep it from being a double connection. So we're seeing most of the time everybody understands it, the guys get it, they work it, but like you said, it only takes that one moment, and they pull the bolts and the beam comes down, and you've got a major injury. So yeah,
And
it's something to be aware of for sure.
And one other thing, this brought to my attention, working off the first member, tying off to that beam, when in fact, at some point in time, it's not going to be permanently secured. If it's on a seat only, I am, and I know OSHA is not going to accept that as a proper tie-off anchorage point. Zero chance. And the one end of that beam is made to another column, and this one's the first one, the second one's come flying in. If there's just a little bit of operator error, just a little bit, or boom deflection or whatever, and they tap that column, that beam's coming off that seat.
Sure.
And you're going down with it. So
I think so then the remedy there would be install a bolt, right? Drill a hole, put a bolt in there so that it's secure. You only need one on one side of the bottom flange or whatever system you use. You even weld it, you know, whatever it might be, something so that that competent person looks at it and says, okay, this is secure. It's not going to go anywhere.
I'm good with that. Finally, sometimes OSHA, I'm trying to be nice, is counterproductive. They came out with the standard in 2002, and they came out with a directive after that, trying to explain what they meant by the standard. Now, understand, the people doing the explanation weren't part of the negotiated rulemaking process. They were just engineers or safety people working in the Office of Construction. And so the two main issues that are really very controversial, no one has been able to solve them, is the one requirement: a fully planked or deck floor or nets shall be maintained within 2 stories or 30 feet, whichever is less, directly under any erection work being performed. Well, OSHA came out with a interpretation and says, if you have 100% fall protection program, you don't have to do this, which drives me crazy because they now have, the standard is there, and they now have said, if you have 100% fall protection, so it's okay if a guy goes down and is arrested, that's okay, and we don't have any way of getting to him, that's okay with OSHA. But I don't understand that, and I would, if my recommendation is, if it were me, I would continue to work off of this fully planked or deck floor and nets being maintained 2 stories or 30 feet. You never know about your fall protection system. That's all I'll say. That's not 100%. Never has been and never will be. And you got to have that extra, in my mind, it should always be there, but we have to limit the falls if we can at all. And secondly, the shear connectors such as steel studs, steel bars, steel lugs, reinforcing bars, deformed anchors, or threaded studs shall not be attached to the top flanges of beam joists or beam attachments so that they protect vertically from horizontal across the top flange of the member until after the metal decking or other walking working surface has been installed. That's a good standard. We don't want tripping hazards on these walking working surfaces. And even though I am hoping I'm tied off, it still don't want a tripping hazard up there. And why OSHA would come out and say, that's okay, is beyond me. After the negotiated rulemaking went all the way around this and decided it's this way, they fully knew that there's a requirement to protect with some type of restraint system or fall protection system. But I'm not clear on what all of you are doing. Are you following the standard, or are you following the interpretation, which is not a standard? And my suggestion is do the right thing and do the safe thing. Any questions on that?
I don't have any. We see one here. I had one actually that went away. Someone asked, oh, here it is. I'm sorry. Or before I ask that question, here's another one that someone has sent in, and I guess I'm going to ask that person just to clarify. They asked why the international can't make this requirement mandatory for signatory union contractors. If this person could maybe specify what rule he's looking at exactly, I'd appreciate that. But first, we were asked, can you use bridge clamps as anchors for fall arrest systems? So that would be typically your bridge clamp is that heavy C-clamp that can really tighten on. Is that an acceptable anchorage point?
If it meets the anchorage requirements, which is 5,000 on a non-engineered system, or a lot less if it's an engineered system. So if it meets those requirements, I don't see any. You can do anything you want as long as it's not going to give way. Okay,
and following up on that, I would say to this person, what Jim just said, can it meet those requirements? If a bridge clamp fails and use it as anchorage point, I don't know how you could defend that in court. I don't know how you could say, we tested it, we engineered it, we did this. It's a bridge clamp. Would it hold? Probably. If it doesn't, can you defend your decision? I doubt it. I kind of doubt it. So I would, if it were me, just shooting from the hip, I would avoid using bridge clamps as an anchorage point for fall arrest system. There's options out there. I would urge you to look at them. So moving on, again, I'm waiting for clarification from this person on what rule they were looking at. Joe Fryan asks, what can you do as the erector that installed perimeter cable? You're on site, but the controlling contractor will not accept custody, but other trades are still working at that level. So you're still there, you're still working, and all of a sudden the plumber's up there laying pipe, and the electrician's there putting down his stuff. And you want to say, hey, we want to turn this over because we've got people don't work for me here, and they refuse. Your thoughts there?
Wait till the end of the day and take it out.
Okay. Same thing.
Yep. I mean,
Okay.
this is, I mean, it's your property. You've installed it. You want to turn it over. You want to give it to them. I can't imagine a controlling employer not accepting it. I just don't get that. But they'll, like you said, if they start taking it down, there's nobody else there. They're gonna change their mind because they're responsible. This is right in the standard. They're responsible.
Okay. Understood. And sort of like before, if they won't accept it, take it down. End of the day, you're going to take it home. It's up. It's yours. And again, like I said,
I want to repeat,
had to resort to that tactic.
Each employer has a duty to provide a safe workplace. So when you take your fall protection down because nobody wants it, the general contractor, all fall protection, sometimes you leave it, sometimes you don't. But if they want it, fine. But it still becomes the exposing employer's responsibility to make sure that it's working and it's being used. And that's just the way it is.
Okay. Got some clarification on the next question. This person is referring to the 2 floors or 30-foot rule. He's asking, why can't the international make this a mandatory requirement for signatory union contractors? There are still a lot of union contractors who not believe nor will follow this rule. This is where the international needs to step up. I can start out with that and then you can take over. I think one of the things the union typically in bargaining things don't often get into the safety issues, this particular ones. So maybe they could. This would be one to have asked for Eric certainly to weigh in, but he's asking about that rule. Could that not be a requirement for signatory union contractors? I don't know if you have any other thoughts on that, or you've seen anything like that where it's been negotiated into the agreement.
I have not, but I know that many of the impact contractors were on the negotiated rulemaking committee or had people on it and were in total consensus of this standard. And those contractors do it, regardless of what OSHA said. But,
yeah, and I would say again on those that become issues that really are contractual. When in your area, if that's an issue and you want to throw that out the table at time of negotiating, I think that's the way to do it. But I think that'd be a hard one to answer from here. But I think that'd be a good one to ask of your local leadership, your business manager, someone of that nature, or take it up the chain to the district council presidents, whatever. That's a good reason to come to the Impact Convention because they're all there. Great way to talk to people and rub elbows in the hallway. So next one, Roger Manuel asks, with your comment on planks or floor at 30 foot, how do you deal with the perimeter of the building without a cocoon system of some kind?
well, again, dealing with the perimeters by this issue, no exposure, no hazard. So if anybody is there, we don't have to guard anything at the perimeter. No exposure, no hazard. It's always been that way. But you got to keep people away from those additional hazards if they are in fact created by us fully planking or netting or decking those floors. But they're there just as interim, mitigating a fall. They're not going to stop anybody. They're mitigating. We have the fall protection system in place to stop it. This will mitigate it if there's not being. That's all.
Okay. Here's a good one. Actually, Justin William asked, when and where is the next safety director training course? I actually spoke with Steve Rank this morning. I know they're working on the next one. I don't think they have it picked out and dates given yet. He did mention also they're very close to putting one together for Canada, the first one in Canada. So, because I know Canada, their version of OSHA, and sorry, I don't recall the name of it, but it's different. Some of their rules are different, but they are working on one for Canada. And I'm sure they're working on one. I don't know, Jim, if you have anything to add, if you know of the next one might be coming up outside of the Canada one.
I know the last one was in Henderson, Nevada, and it was fully attended, and the reviews are unbelievable, to be honest with you. And many people, I've just found this out today, a lot of the ironworkers have gotten positions as safety people as a result of this training with union contractors, obviously. But it is not everybody's going to make a safety person, but this is a really good start. It is 100% better than the OSHA 30. I mean, the OSHA 30 is like nothing compared to what happens at this. You have 9 or 10 instructors over a whole week and constant back and forth. A lot of good examples and some of the top people in the United States doing the training. So I can't recommend it highly enough. It's something that it's something I've never seen before by anybody.
Yeah, and I would back that up. Like I said, I've had multiple people go through the program. They rave about it when they get back. The knowledge they bring back is invaluable. So Justin, another answer to that question might be reach out to Steve Rank, who is the International Director of Safety for the Ironworkers. I'm sure you can get his information off the website, but he's really integral in when that next one is. That and keep your eyes on the website, because as soon as those things are scheduled, they will go up on the Impact website under events. You click on calendar, and there everything is that's going on really around the country. So anything you want to know that's going on, it's going to be there. So next one, Mark Nesbitt asks, doesn't the standard reference rescue plans for steel erection? I have used that as an argument for the contractors who want to erect above the 2 floors using percent tie-off if they can't get the employee down in a timely manner. So your thoughts there?
There's no rescue section in subpart R.
Okay. So
But
the answer then is no.
And I'm pretty familiar with the 1926 in general, and I don't see anything in there. There's ANSI standards on that and something similar on that, but I don't see OSHA dealing with it.
Okay. All right. So next question from Jack Lar. Even though our apprenticeships train apprentices in fall protection, per OSHA standards, the employer is responsible for training employees. I have experienced employers trying to pass off total training responsibility to the apprenticeship after an incident. Are they still not 100% responsible?
According to OSHA, they're 100% responsible. The department has accepted the training as training under some of the standards, the apprenticeship program. They have accepted it. And there's a memo out there. And Steve can provide that to anybody that wants it. I remember seeing it, and I know it's there. That doesn't relieve you of all your training responsibilities, because the specific issues you have, they have to train. So, and I would be doing my own training, because as the older we get, the longer ago the apprenticeship program was. So, and there are plenty of people out there that maybe even haven't gone through. So,
yeah,
very important to do this training. You got to be able to document that you're training.
I would add into that, I went through the apprenticeship in 1985. What I got trained on and what's pertinent today, not even close. And the ironworkers, Lee Worley heading that up, have the best apprenticeship programs across the country. I've been fortunate enough to have been in a lot of the training centers, very close to the 512 Training Center. I actually went through the apprenticeship with their director of training or apprenticeship there. And what we're training the young men and women today is nothing like it was then. So those are the people that I think employers be aware of. Those guys like me, they're in their early 40s, 50s, 60s, that didn't get a lot of that training. So don't just rely on the apprenticeship program, and it is not their responsibility. They're world class. They're doing a great job for us, but don't rely on them 100%. So yeah. Roger asks again, but what about when you are connecting? And I can't recall which question he asked before, but do you recall? I'm assuming he's referring to the 30-foot rule.
He's probably referring to the 15 to 30-foot rule for connectors, right?
Yep.
Look, that all goes away if the controlling employer says 100% fall protection. All of that goes away on your job, but it's not going away as far as OSHA is concerned. OSHA enforces to their regulations, not the general contractor.
Okay. Yeah. Oh, and I go back. Here's Rogers. I found it. He was the one who commented on the planks or floor at 30 foot. How do you deal with perimeter without a cocoon? So again, it's got to be what OSHA requires, right?
Yep.
All right. Justin replies, and that's great. It looks like he'd like to go to Canada. And hey, wouldn't we all? It's hot here. The last time I was in Canada, I was walleye fishing. So I hope you get up there, Justin. And again, follow the website and see when that next class is going to be. Anonymous asks, what qualifies an iron worker to be a safety director other than the director's course? And is the international responsible as a trainer of those iron workers? And will there be continued education for those individuals? So let's start with the first portion. What qualifies an iron worker to be a safety director other than the director's course?
They have to meet the qualified person standard and interpretation. I can read it to you if you want, but they have to meet that. And actually, when I say they have to meet that, there's no standards on being a safety person. That's unfortunate, but it's experience and it's the knowledge that you've gained from that experience that makes you, and knowing the work, knowing the job, knowing the men and women that are out there can make you an excellent safety person. Safety people are there to assist management in the enforcement of their program and the implementation of their safety program. That's what they're there for. They are not there to stand next to every iron worker and tell them what to do. That's not their job.
All right. The next portion of it is the international responsible as a trainer of these iron workers. And I would say he's probably referring to if there was if there's a problem, and I would certainly think no, because they're your employee, you're responsible for this person. Any thoughts on that?
You can sue anybody for anything. You can sue anybody for anything, but that's not going anywhere.
Okay.
That would so is your college course responsible that you took on this? Are they responsible?
Yeah, exactly. Okay. Will there be continued education for those individuals? I don't know of or haven't heard of any continuing education or refreshers coming up. There may be. Have you any thoughts on that?
Yeah, this is the start, not the end.
Okay.
That first course is just the start. Then we're talking about going to the OSHA classes. Then we're talking about getting trained in specifics by your own employer on areas that are very important to them. All of that, going to the ASSP conference and seeing the technology that's out there, or the National Safety Conference that's seeing the technology out there. Going to Impact, becoming involved in the Impact roundtables. All of those things are just it moves on. Working with the local union and what they are providing, so you get better every day. You don't start out as a safety guy or gal and be the best ever. You work at it.
Understood.
That's how it works.
Yep, I think it's get involved. I'm telling you, there's a lot of resources out there. The iron workers are doing an amazing job, and get involved. Next question, and I might even be able to kind of tie into this one because it's kind of something we've been working on around here. Why can't the journeyman have mandatory refresher or recertification training? You know, all the apprenticeship programs are you know, we got these beautiful buildings, but it is a difficult to get the journeyman to come back because usually they're giving up a Saturday, they're giving up a weeknight, and so there's been different efforts, different things. Sometimes they happen within the CBA, the collective bargaining agreement. Sometimes they happen outside of it, but it's a tough one because you know, you got iron workers, like we're all human, right? You work hard all week. You want to go to your kid's basketball game. You want to do this. You want to do that on weekends. So that's a difficult one. I know a lot of people are out there putting their heads together, trying to come up with the answer to that. How do we get the guys in the building to keep them certified, keep them refreshed? But one of the things that has worked for your contractors out there, take a day, pay them, get them in a classroom. I've done that. You shut down for a day. Sometimes it's tough to tell your contractor we're taking Friday, July, whatever off, but you do it and you get the guys in a room and you hit them with the training. So it is a problem that's out there, but it's something I know a lot of people are thinking about and trying to get addressed. So,
In addition to that, Steve Rank and I are working on an out-of-the-box training for iron workers and for contractors. It's called Why It's Important to Be Safe Training. Most iron workers and most workers know how to do their job safely. Sometimes other things come around and other things happen, and we're all of a sudden doing something we know is hazardous. Why it's important, no one's training on that. How to work safely, how to wear your heart, how to tie off, how to do a double connection. That's all being done. But why? And the why, we did a pilot program with Harris Rebar. They trained every single worker in their United States and Canadian operations in conjunction with the iron workers in why it's important to be safe. An 8-hour and a 4-hour presentation, hands-on, no slides, all interaction. And the reviews and the results of that were amazing. That people walking out of that class for the first time really understood that it's not just about them. It's if they get hurt or killed, who they're affecting in the world, everybody that loves them and works with them. And getting to understand, if I do this and I am not here anymore, how terrible it will be for the ones that love you and depend on you. That training, we're looking at possibly, Steve wants to do it in selective cities with the ironworker contractors and do maybe 4 hours in a location with 200 or 300 people in it and try and get that interaction going around the country. So that's something that's on the horizon.
okay, great. Yep. So it sounds like we're going to address that. Moving on here, because we got a bunch of them, we want to get through them. Do you see more GCs upping the required training to get onto the job site, i.e. fall protection, OSHA, PPE? I can answer that. We are seeing that. More and more general contractors that are going way above and beyond what they're requiring. And it's actually, I think it's a great thing. I'll speak to, I don't know how specific I should get, but Holder Construction is somebody we do a fair amount of work for in the West. They have really stepped it up, and it's great. Some of the safest jobs I've ever walked on. And so I think you're seeing that out of your larger and more sophisticated generals, that absolutely they're really stepping it up. They're putting safety first and foremost. And I look forward to more of it. So you got anything you want to weigh in on that?
I see contractors getting the bid because of, or as a result of, their unwavering commitment to their worker safety. I see that. And that bid is not always and not even close to the lowest price. So I see the very responsible owners out there and general contractors selecting the best possible contractors, because in the long run, it's going to be a lot better. And I
Correct.
see that it's not happening. It's very seldom happening in the open shop world. but it is happening in our world, and it's happening more and more.
Yep, I would agree with that, and we want to see that happening across the board and in the open shop world, right? That's one way we hopefully can get them to join over, cross over, is see that safety is first and foremost, and it gets you work. So that question came from Antonio Aponte. Thank you, Antonio. Next one from Andre Mondo. In this world of trade stacking, which I'm not sure what that means, but who's responsible for falling debris? Okay, during the erection and detailing, the controlling contractor won't take ownership. The erector is fulfilling the requirements, but no exclusion zones are being maintained. And he's talking mainly industrial or floors and elevation are not typical, with no extended perimeter netting. So who's responsible for falling debris during erection and detailing?
It is a specific requirement in subpart R saying the controlling employer is responsible for barring work underneath the erectors. Right
Okay.
in the.
All right. I know we're on a job right now where tethering is required. Every tool is tethered. Sure is a lot of little cables hanging off of a man, but they've required tethering for everything, and it's been a learning curve for sure. But I see that coming. I see it coming more and more, tethering of tools. So, all right. You just gave this anonymous. You just gave a good representation of then versus now training. Will there be any mandatory training for journeyman iron workers to get them up to speed, or will all this new training be strictly be for new iron workers only? I think that again, that's that age-old problem of how do we get our JIWs in and trained to the new standards and the new things. It's tough. I know if you look at a body of JIWs in any given local across the country or Canada, you're going to have that 30%, and I'll just use round numbers, that are going to be in there on the cutting edge. Another 50% that will show up when they can, and 20%, good luck finding them. So making these things mandatory for JIWs is tough. But I would say weigh in there and do what you can. Join your local apprenticeship committee. Talk with your business manager. Let's try to team up and figure this issue out. Someone's asked if the session's recorded and available to view later. I've gotten that question several times. We've got some of that. My answer is check back on the website. I believe we're going to be able to do that, but I'm not the IT guy. But it's been great. So Garth asks, I have been the safety person for our company for 10 years with no training, but I have been an ironworker for 40 years and write all our site specifics and manuals for 8 years, but have had no training in it, but have had no issues with safety. So I don't know if there's a question in that, but what are your thoughts there for that guy that maybe has had that role for 10 years and he's been in the trade for 40, maybe hasn't had a lot of specific training?
I believe he's more qualified than anybody else would be in that particular job. He should be doing the training. He's been an iron worker. He knows the work. He's worked 10 years in the safety department. He's writing the site-specific plans, and I will just add, more than likely, it's a very good program. So what else does he need? I don't think he needs some college professor giving him a psychological rendition on whatever. So he doesn't have to worry about leading indicators, trailing indicators, system safety. He's down on the ground floor, working with the men and women out there, doing the right thing and making the right things happen through his management. That guy is fully qualified, in my opinion. Okay,
so, and I don't disagree at all. I'll play a little bit of devil's advocate here. Let's say I'm the OSHA inspector. I'm on site. I'm a newer OSHA inspector. I find some violations. Garth is there. He says, "Hey, this is," and does that give you any concern maybe that he doesn't have that list of things I've done to be this?
No.
What are your thoughts there?
It doesn't bother me a bit that he doesn't have letters after his name. They're all certification issues. They're not qualification issues. He is qualified. He's more qualified than any young man or woman working out of school and working 2 years with a CSP. That's going to make them more qualified than him? No way. That guy
Okay.
is absolutely what you're looking for as a safety person on your job.
Great. Okay. Appreciate that interpretation. And again, anybody out there that maybe is in that boat, boy, if you get a chance and you can go to that week-long training, that's great. But yeah, like you said, you can't take some training and yet replace 40 years of experience. So keep at it. Keep at it. So well, following up, he asked again, he said his question is, do I have to take the course or can I continue doing it my own safety? I think we kind of answered that sounds like you're fully qualified and up and running. But hey, if you can get there and take it, great. I'm sure they'd love to have you. And even old dogs can learn a few new tricks now and then. So I get taught a couple every now and then. Anonymous asks, unions could do the same thing, take a day, pay them. Why is this always a contractor issue? This is supposed to be a partnership. Again, I don't know if that's a question necessary for Jim. I would say reach out to your business manager, reach out to the training center. I think that I know in the JIW and 512, the committee, it is a group thing, and they are working at trying to solve it as a group thing. And I think that's the only way it's going to get solved is that we all put some skin in the game and to try to do it together. And I know those efforts are happening, but it is a tough one. So reach out and jump in there and do what you can to help solve the problem. All right. Ken Schaefer asks, I believe OSHA rescinded the de minimis violation of work above 2 floors level if 100% fall protection is provided in a directive per letter. And then I don't know if you can see this, Jim, but he quotes some things. So your thoughts there?
OSHA mumbo jumbo is my thoughts on that one. I mean, they're not rescinding anything. They came out and said, okay, if you didn't do, if you don't put the decking in, etc., it's a de minimis violation. Then they rescinded that. De minimis is nothing. It should be taken away for everything. It's you're either in violation or you're not in violation. And more importantly, is it safer the way the standard had it, or is it safer the way OSHA doesn't want to do it? And I say it's safer the way the standard originally intended it to be. And that's the way we should do
it. Okay. We got a comment, looks like from Jack Lair. He says, we as iron workers should always be wanting to expand and sharpen our skills and be progressive. Therefore, when it comes to retraining certifications, it should not depend on whether we're going to be paid to go or not. The more qualified we are, the more valuable we become. And of course, I think everyone would agree with that statement. And that is something I know the iron workers are working towards. Again, it's getting that, finding that time, getting it done. So again, I'd urge you to jump in with your local in your area and do what you can to get guys in and continuing education, continued training. So it looks like we're down to one more, and this person, again, more of a comment. He says more and more GCs want people with the BCSP credentials, more and more. How do you reply to that? I mean, what when they want it? We just go out and get it? I know that the training's out there.
They want it for the wrong reasons, in my opinion. They want it for liability issues or OSHA issues. If the guy has that certification and he's actually qualified, or the gal, I'm for it. But don't limit yourself to that. There's plenty of people out there that are extremely qualified that don't have those letters after their name. That's just the way it is. I mean, we fight this battle is certified versus qualified. It doesn't mean you're qualified to get that. It just means you're certified. And you pass the test. You know how to multiply. So I get it, and I'm not critical of it. I think it's a great program, but don't limit yourself to just that, because you will get unqualified people. Now, if your requirements are that that certification and qualifications, I'm good with that. I'm good with that. That's fine.
Okay. Well, I don't see any more questions. If any more pop up in the next minute or two, we'll certainly answer them. Jack replies, great job, and we appreciate that. Jim, I want to thank you for your time. I want to urge everybody watching, Jim is FDR Safety. If you have any needs, questions, follow up, reach out to him. I'm sure he'd love to answer them. We've actually worked hand in hand with him several times and been very, very pleased. He's a wealth of knowledge. Use him. He's a great friend to the ironworkers and to Impact. And I just really want to thank you for your time today and your expertise. I've enjoyed it, and I'm sure everybody who's been on has also. So
Thanks, Pete.
All right. Well, with that, everybody, we look forward to our next call 3 months from now. You'll get the emails, and it's going to be good. We're going to have Steve Rank on, who's the Director of Safety and who really works hand in hand with Jim all the time. We're going to tackle more issues that's going on. In the meantime, be safe and make sure everybody goes home to their family every night. That's what counts in the end. So thanks again, Jim, and we'll see you around.